Reforms under Warren Hastings from 1772 to 1785. District Diwani Adalats were established in the districts to try civil disputes. These adalats were placed under the collector and had Hindu law applicable for Hindus and the Muslim law for Muslims. The appeal from district Diwani adalats lay to the Sadar Diwani Adalat, which functioned under a president and two members of the Supreme Council. District Faujdari adalats were set up to try criminal disputes and were placed under an Indian official assisted by Qazis and Muftis. These adalats also were under the general supervision of the collector. Muslim law was administered in Faujdari adalats. The approval for capital punishment and for acquisition of property led to the Sadar Nijamat Adalat at Murshidabad, which was headed by a deputy Nizam, an Indian Muslim, assisted by Chief Qazi and Chief Mufti. Under the Regulating Act of 1773, a Supreme Court was established at Calcutta, which was competent to try all British subjects within Calcutta and subordinate factories, including Indian and Europeans. It had original and appellate jurisdictions. Often the jurisdiction of the Supreme Court clashed with that of other courts. Reforms under Cornwallis from 1786 to 1793. The district Faujdari courts were abolished and instead circuit courts were established at Calcutta, Dhaka, Murshidabad and Patna. These circuit courts had European judges and were to act as a court of appeal for both civil and criminal cases. The Sadar Nijamat Adalat was shifted to Calcutta and was put under Governor General and members of the Supreme Council assisted by Chief Qazi and Chief Mufti. The district Diwani Adalat was now designated as the district, city or the Jila court and placed under a district judge. The collector was now responsible only for the revenue administration with no magisterial functions. A gradation of civil courts was established both for Hindu and Muslim laws. Munshifs 1. Munshifs court under Indian officials. 2. Registrars court under a European judge. 3. District court under the district judge. 4. Fourth circuit courts as provincial court of appeal. 5. Southern Diwani Adalat at Calcutta. And 6. King in Council for appeals of £5,000 and above. The Cornwallis court was laid out. There was a separation of revenue and judicial administration. European subjects were also brought under jurisdiction. The government subjects were answerable to the civil courts for action done in their official capacity. The principle of sovereignty of law was established. Reform under William Bentick from 1823 to 1833. The four circuit courts were abolished and their functions transferred to collectors under the supervision of the Commissioner of Revenue and Circuit. Sadar Diwani Adalat and Sadar Nijamat Adalat were set up at Allahabad for the convenience of the people of our provinces. Till now, the Persians were the official language in court. Now the suitor had the option to use Persian or a vernacular language, while in the Supreme Court, English language replaced Persian. 1833, a law commission was set up under Macaulay for codification of Indian law. As a result, a civil procedure code 1859 and an Indian penal code 1860 and a criminal procedure code 1861 were prepared. In 1860, it was provided that the Europeans can claim no special privileges except in criminal cases, and no judge of an Indian origin could try them. 1865, the Supreme Court and the Sadar Adalats were merged into three high courts at Calcutta, Bombay and Madras. 1935, the Government of India Act provided for a federal court set up in 1937, which could settle disputes between governments and could hear limited appeals from the high courts. धन्यवाद. Thank you so much.